Hey everybody, welcome to another edition of Reasonable Doubt, brought to you by the Harris County Criminal Lawyers Association. I'm your host, Jimmy Ardwan, along with my co-host, Julio Vela. Julio, what's going on, man?
Very happy to be here today. Rio Grande Valley representing strong here today.
That's right, that's right.
True.
We got a couple great guests in the house. Been trying to get this woman on for a long time. Emily Detoto finally makes it to our program.
Thank you. It's a pleasure to be here.
Oh, it's absolutely a pleasure to have you on, as well as the man who's trying to challenge Julio in the hair growth contest this week, Paul Morgan. How are you, my friend?
Oh, not bad. How you doing?
I'm good. Glad to have you back on the program. This is your second trip here, huh?
Yeah.
And I assume everybody at this table is doing a lot better than Ryan Lochte and the U.S. swimmers at this point, huh?
Yeah.
You lie, you lie. You joke, you lie.
I mean,
Yes.
seriously though, did nobody think to show these guys either broke down palace or locked up abroad before they sent them off to Brazil?
Yeah.
What the hell?
I want to know how Ryan was smart enough to get on the plane and get the heck out of there before the others.
Hey,
Right.
And the other one too.
you know what? Somebody told me he finally won his first gold medal getting out of Brazil
Yeah.
fast as
That's
he
a
could.
good one.
Jesus, man.
Right. We got a great show for you, ladies and gentlemen. We're going to be here the next hour talking a little criminal justice and hot legal issues with Emily and Paul. We'll open up the phone line starting around 8:30. 713-807-1794 is the number. We also have Twitter up at HCCLA_TV. You can send us your questions and comments right there. But let's jump into the big news of this week, because we've had a lot going on. Unlike last week, where we didn't have a whole lot of local stories to talk about, this week we're loaded with them. And the first one is a case that y'all didn't try because it got dismissed yesterday. And it's kind of a big deal. I mean, in the words of Ron Burgundy, it is a big deal. So you guys show up. It's a felony drug case, and let's set the stage a little bit here, because not only was it a felony drug case, but it was a 25 to life felony drug case.
That's right.
Where your client, if he was convicted, was going to get a minimum of 25 years. And this was a meth case. And the case had been set for trial, was supposed to start Monday. You guys had a suppression issue that basically the judge was going to roll you to Wednesday.
Right.
Then you were going to pick a jury after that. And then the state decides to dismiss. All due to some very good detective work by one Paul Morgan sitting to my left. So, Paul, shed some light on what's going on here.
Well, I came onto the case after the gentleman bonded out. He made a fairly large bond, which in and of itself is cause of concern, because he bonded out while this charge was pending, and he had to retain counsel, so he came in, he found me. I came onto the case, and there was discovery issues that we ran into. And the two prosecutors who were on the case were Bianca Robinson, who's the number 3 in the court, and also Justin Kiter. We had been going back and forth on negotiating what would be an appropriate plea deal, and they were not at 6 at first. They were in the double digits.
And that's 6 years, not 6 months.
Yeah, that is 6 years. That's right.
Prison, not I guess.
County.
Right.
Yeah.
Prison, right? We're talking about like National Geographic prison.
A Texas prison.
You say that they're offering your clients 6. And when did this case start?
This case started back in either June or July
Of last year.
2015.
Okay. And at any point, I mean, did you get a lab report or anything that purported to be a lab report?
Yes, I did.
Testing and confirming the drugs?
Yes, I did.
Okay.
The drugs were actually seized. After they were seized, they were sent to either the Harris County Forensic Institute of Science or the HPD lab. You're going to have to excuse me.
I don't know, the
it was
acronyms
not
are so
HPD.
close. I'm not sure if it's
Right.
what is it, Houston Forensic
Yeah.
Science Center is the
Right.
old HPD crime
I
lab.
think it's the Houston Police Department, Houston Forensic Crime Center.
Yeah.
Right. It definitely was not. It definitely was not HPD.
Yeah. So I think it was the one off of Old Spanish Trail.
That's the county.
That's right.
And
Okay.
they actually tested the paraphernalia and the meth that was seized, and then it was sent back to Precinct 4
For storage and
for
keeping.
for storage and for custody, and to basically, I don't know. I mean, obviously hold it, like just hold the evidence where it should be. what sickens me about this case is that at one point we actually had plea deals and plea papers filled out with a prosecutor's name on it, and I'm going to leave that prosecutor's name out because
They're no longer with the office, so it's not relevant.
Yeah, so it's not relevant. So this man was about to sign, and he changed his mind at last minute. It got put on the trial docket, and every time we had a trial setting, the offer was still 6 years, or without an agreed rec, go to the judge, 6 years, 6 years, 6 years. And at one point, I went into I went up to this. I went into 1201 Franklin. I set up an appointment with Bianca, and I said, "Hey, look, these are what I think your issues are." I pointed out the legal issues. I pointed out the fact issues. I didn't think that they would be able to link the drugs to my guy, and also there was serious officer credibility problems. There was a dash cam and an offense report, and the two vastly contradicted each other. So I thought I would be able to just get the case thrown out because the officer was clearly fabricating facts on an offense report when his dash cam just contradicted every little thing he said. So I'm trying to work it out with Bianca in her office, and Justin Kiter comes in, and he's not even on the case. So Justin comes in, and he says that there's no way that this offer is going below 6, and I said, well, that's just preposterous for a case that's not even worth a 1244A, to be, frank and honest with you. So if you don't want to offer anything, we can just set this up, we'll try it and go to war. And he actually interjected himself, and he himself wanted to try the case.
And then you showed up yesterday.
Yes.
Now, at some point, you discover that all the drugs have been destroyed by Precinct 4.
I'm just going to...
The evidence you need in a drug case, the drugs, has been destroyed by
let me
the good old Precinct 4.
Tell you how this went down, because it's going to just sound as ridiculous as it sounds. I end up subpoenaing the personnel file for the two officers, Officer Ruiz and Officer Drake, and they're the two who were involved in the arrest of the defendant. And the custodian records, his name was Lieutenant Nicholson. So I subpoenaed Lieutenant Nicholson, and I asked for, and it's like a standard subpoena, please give me all the personnel files, and then I added in all MDT records, ALV records, and a video. And so he sends me back an affidavit saying, we've destroyed everything. And so I go...
When did you get that?
Oh, like...
Tuesday, the day before trial.
Yeah.
Really?
Like in an affidavit. And you saw right at the bottom that they have a policy that they destroy all electronically generated evidence after 90 days. And so I hit him with another subpoena, and I go, you need to come to court, and you need to come to court for a pretrial hearing, and please generate a list of everything you destroyed. So I call him up, and I double check on what he had destroyed. I go, hello, my name's Paul Morgan. I'm the guy who's subpoenaing you. And
it's probably like, oh, that guy again.
Yeah. And so Lieutenant Nicholson basically just laid it down for me. He goes, oh, yes, I have the list right here. We destroyed the 4 grams of meth, the syringes, the 2 pipes, and the bag that was containing all the contraband we have labeled as missing.
Jeez. Now, Emily, you came on this case help out.
Right. Paul came to office with us several months ago, and Paul, being an up-and-coming lawyer, I was interested in working on some cases with him and vice versa. He was more excited to work with me than I was with him, but
Of course.
I digress. And we
Way more excited to be on TV with you.
Oh yeah, definitely.
Well, I'm excited to be on TV with you. So.
Well, so we started working up the case. I had been to the Jerry Spence Trial Lawyers College. I'm a faculty with the Trial Lawyers College, so we were going to work up the case in a non-typical way. Try to think outside the box, not just do the normal defense attorney, jury selection, etc. And so I came on the case, and we discussed, and my goal was I was going to cross-examine this phantom independent witness that the state sprung on us last minute. When they realized they had issues with the officer's offense report and the dash cam, they said they had an independent witness. And they claimed that the independent witness was unimpeachable. And upon a look into his criminal history, we found that he had several theft convictions. He had been to the state jail for theft, and he was not unimpeachable. He gave a written statement to one of the deputies there after the arrest that consisted of 2 sentences. It says, "I saw the guy throw the bag." And so, as you can imagine, I was looking forward.
That's unassailable.
It's unimpeachable.
Yeah, and it wasn't sworn, and it wasn't dated, and it wasn't witnessed, and so I was really looking forward to cross-examining him. But thanks to Paul and thanks to an officer who was honest. He was dishonest. Well, I don't know how to put it. I mean, he was following protocol, but he was honest enough to admit that he destroyed the evidence.
Right.
Well, that brings us to the real issue with this case, which is Jeff McShann told ABC that this office had known since April that the drugs had been destroyed.
And he's the spokesman for the DA's office.
That is right.
The media relations.
That is correct. So I was entertaining plea negotiations with the felony chief of the 184th on a dopeless dope case.
Emily, you used to be a prosecutor.
That's right.
I mean, when you hear all this going on, you get the list of the destruction, you find out that they've known about it, that the office, at least in some capacity, has known about the destruction of this evidence. What's the first thing that goes through your mind?
I can't say it on TV, but it's an O expletive. As a number 3 prosecutor, I understand that they have a lot of cases. I understand that dope cases aren't the highest priority. I understand that they're overworked. But to represent that you're ready to go to trial and not having made sure that the evidence is actually available, I don't want to fault the prosecutor for this. I just think that she probably was overworked.
So let me ask you this, and for our viewers too. In a dope case, is it enough for there to be an allegation and maybe an independent witness that there was drugs? And does the prosecution or does the government have to go to the next level and actually present that evidence in court for them to actually gain a conviction?
Right. Well, the answer to that would be yes, because it's called chain of custody. They have to mark the evidence, tag the evidence, transport it to the whatever agency it is, and when it's checked out to be tested, it has to be checked out. When it's checked back in, it has to be checked in. And you can't introduce a lab report unless you're able to tie what it is that they tested. So although they did have a lab report that purported to be methamphetamine, they couldn't make it relevant in the criminal trial without also producing the drugs.
So when the prosecution finds out that there's actually they're not going to be able to say, here's the methamphetamine, ladies and gentlemen, and you should convict this man. Did they dismiss the case automatically, or did you actually have to go through a hearing?
Okay, so I thought I was actually going to have to go through a hearing because they had just been so aggressive in court with getting this man to take 6 years. I thought I was going to have to go through a young blood hearing where I'd have to present that the evidence was destroyed, that it was destroyed intentionally, and it was destroyed in bad faith. So I thought it was going to turn into a hearing. I actually was shocked to see that they nollied it. But they didn't believe that the meth was destroyed at first. So before we get going, after I subpoenaed that officer and he told me that the meth was destroyed, I conveyed that to the state, and they said, no, you did not hear that right. They just destroyed the bag.
You didn't hear it right. You got it in writing.
No, that's after I hit him with the second subpoena, and that second subpoena said, please bring me a list of everything you destroyed. And I actually have a list.
Right.
And I just want to know why the bag is missing. Everything else was destroyed, but the bag was missing.
So let me get this straight. They're about to try to put a man down for 25 to life, and they haven't even checked or verified that they have a case to present.
Okay, that's the other thing that is concerning to me, because I was in Bianca's office. I was in that court frequently. They knew the issues I had with the case. I had constantly plea bargained with them. At one point, I went in, I showed Bianca the CD. I said, look, that's where your officer's lying. That's where your officer's lying. That's where your officer's lying. Give him a call, have him explain that. And she called the officer. She called the officer, and the officer gave her some story. How do you call the officer who led the investigation and not know that the drugs he seized were destroyed?
Do you know who the officer was? Is there a record, speaking of the chain of custody, how this just disappeared? Is there a record
They dismissed the case before I got my hearing. I came in, I had Lieutenant Nicholson, who had basically just told on everybody, told on Officer Ruiz, told on Officer Drake, told on the prosecution, and even told on himself that basically evidence had been tampered with. And I wanted a hearing. I wanted to ask him which officer did this. I wanted to ask him, when was this done? When did you tell the DA? Did these DAs know about it? And Judge Crocker said I had no standing for the hearing because it had been dismissed.
Well, and now today we hear that a number of other cases are being dismissed that have evidence out of Precinct 4 that was destroyed.
Right.
I mean,
well, I like to give people the benefit of the doubt. I don't like to think that there's anything nefarious going on. But if a case is dismissed, it's closed and they no longer have to give Brady notice, which means exculpatory or mitigating notice, i.e. that, oh, we destroyed the drugs in your case too. Mm-hmm. It can be perceived that they're being proactive and that they don't want to put innocent people in jail, or it can be perceived that they're CYAing and scurrying around and examining all Precinct 4 cases and realizing that this is not a one-time thing. We have it in writing that it is their policy to destroy evidence after 90 days. And so it calls into question pending cases and past cases.
yeah, I mean, this seems to be, there was an issue that I remember a while, not in the not so distant past, about them basically trying to get people to take plea deals, which now they've ended, of course, before the lab reports came back.
Right.
Before even just a basic lab report, let's set aside, whether retesting or defense testing has been done, but before they were trying to push plea deals down people's throat on just without a lab report coming back.
Well, it's not even before, it's still the policy that if it, in fact, it's written on the front of the file, if set for trial, get lab.
Yeah, I mean,
So it's not like if we think it's just to get the lab before we try the person, then charge them. It's like, oh no, if they exercise their right to
go to
trial,
trial.
then we'll test it.
Exactly.
And on the heels of Precinct 4, just 2 or 3 months ago, about 200 DWI videos had been lost in their Precinct 4's computer had crashed.
Oh.
Funny you bring that up.
What's the deal with Precinct 4, man?
So
I don't know if he's up for re-election. You might want to.
yeah, you might want to address that. When Emily and I were dealing with this case and talking to Bianca told us that this specific Lieutenant Nicholson, had a notorious reputation with her. Basically, she was telling us that she had problems with him preserving evidence, specifically DWI videos, and that this one officer had caused her a lot of distress. So I think that's the issue that you're referring to and that you're talking about, and I think we're talking about the same guy.
Right. I mean, they're losing videos. They're losing bags of evidence. Did they provide? Was there any reason or rationale why they're missing drugs other than a good Friday night or something?
No. And my question is, why would anyone feel the need to throw meth away? Why? Well, why would someone take 4 bags of meth, 2 syringes, 2 pipes, and a pill, marijuana, and throw it away? what? To me, that doesn't to me that doesn't seem rational. It seems like someone had access to contraband that could be sold or ingested, and that's what happened, and that's what I'm implying. And until someone gives us an answer otherwise, I think that's a story that has to be I'm going to stick with.
Well, Paul, they did tell you the reason they destroyed the evidence.
Oh,
It was because the evidence locker was full,
that's right, Lieutenant.
and they needed to make room.
Lieutenant Nicholson did tell me over the phone when I asked him why. He said that that a particular officer thought that the evidence locker was far too full and that they needed to make space. So he threw away four baggies of meth, two pipes, syringes, and now we have a missing canvas bag. So for everyone who is defending a case that has Officer Ruiz involved or Constable or Precinct 4, if you have a black bag involved, might be from this case.
Right.
Paul, tell me how you felt when you heard about this news, and then tell me how you felt and how your client reacted when you conveyed this to him.
Well, it was to say, there's two different sets of emotions going on. You have the client that really doesn't know what's going on, like he has to prepare for a trial. Usually the first time a defendant goes to trial, it's his first time doing that. Then you just have all the pre-trial jitters that a typical defense lawyer has. You know, you got to get your motions set, you have to get your argument together, you have to have your jury charge prepared. So I'm sitting there doing all my work. The client, I'm pretty sure, is freaking out, wondering if he's about to go to prison for the rest of his life. Then all of a sudden, I figure this out, and then I call the client and I go, hey, they threw away your meth, so.
Alleged meth.
Alleged
meth.
I mean, they're the ones who have to prove it's his meth.
Right.
That's the problem that I have with this whole thing, is that they have the burden to prove the case.
Right.
Okay? They're the ones that have to bring the evidence. The evidence goes missing.
Right.
They allegedly know since April that it's been missing.
Right.
And yet they still continue on for 4 more months
Right.
with this, persisting, trying to get a plea out of somebody. I mean, at what point do prosecutors and law enforcement realize, like, hey, if we screw up, we just got to let it go. We can't press on with this crap.
Well, that's the position that the office is taking right now. That, well, we do the right thing, and you can't impute this officer or this agency's action on us, and that therefore they're going around dismissing cases in an attempt, in my opinion, to make it look like they're being proactive now.
Yeah, but I mean, look.
Reactive.
Yeah,
They're
but-
being reactive.
Right.
They're not being.
And I understand. I can look, whatever their position is, but the bottom line is your client was out on bond.
Right.
Okay? So imagine they know about it in April, which they've said they did. They admitted that. If this guy was still in custody, he'd have waited another 4 months to get his dismissal. I mean, look at the article that was in the Houston Press about this guy. You know, he comes out, he gets an allegation against him by a neighbor of his that he assaulted her. He's like, no, she didn't. No, that didn't happen. Cops arrest him, take him in. He spends 2 months in jail, turns down all these plea offers, ultimately to get the case dismissed because it was BS.
Right.
You know? I mean, he spent 2 months in county jail just waiting to get a dismissal. Your client could have spent another 4 months in jail after the state knew about it. That's what's offensive to me in this case, is that if he had not been able to make bond, he would have sat there for another 4 months.
Or chances are he probably would have just pled out.
Right.
Because it's easier to plead out when you're already behind bars than it is when you're on bond. I mean, signing up for 6 years when you're on bond is difficult, but if he was already in custody, I think that he probably would have taken those 6, and we never would have known that the evidence was destroyed.
Well, and that's the other thing, too, that's troubling about this is by taking a plea, if he had taken a plea or if they had gotten a plea out of him, this would have never come to light.
Right.
They would have never have had to answer these questions. They would have never had to acknowledge to the media, hey, we knew about this since April.
Right.
We would have never had this stuff in the public. Did that list that they gave you, did it get filed with the clerk's office? When the subpoena was returned, did they get returned to the clerk's office?
No, you're thinking that the state gave me that list?
No, I know, but when he produced it to you, did it get filed as part of the return in the clerk's office?
No, he just
Okay.
no, he just gave it to me. I'm interested to see how quickly the Harris County District Attorney's Office turns his actions into Brady notice.
I don't think they will, because what's the incentive for them to do it at this point?
Justice.
No,
No, because
Right,
they're
I
dismissing
mean,
they're dismissing all these other
I agree.
cases.
I agree.
So it's like they can take the position, well, it's not Brady anymore because, we're dismissing all these cases. So it's not a Brady notice as to these cases.
Right.
And what is it?
To the viewers out there, this is how it is. And, going back on the article, the tone of it was, well, he doesn't want an apology for sitting in jail because his lawyer didn't pressure the district attorney enough to get his case dismissed. And that tone, it rubbed me the wrong way, because I'm sure you pressed your case to the limit. I'm sure, Emily, on a case last week, you pushed your case to the limit, and it takes going the distance to uncover these misdeeds. And unfortunately, to the viewers, if you get charged with a crime in Harris County, you have to take it all the way to get to the bottom of it. It's not about pressuring these DAs, because I don't know how much more you could have done, Paul, other than going to the office and saying, hey, these are your problems. We got some serious problems with the case. And then superiors in the DA office coming in and saying, well, I'm going to try this case myself, and I'm going to put your client down, or whatever he said. And it's not about pressuring the DA's office, because we do that. To correct this, it has to start somewhere earlier in the process. And the idea that a man was on the line for 25 to life, and it took the eve of trial to figure out that there wasn't even any drugs that they could present to anybody, is baffling to me.
Or
Right.
baffling or deceptive. There's only two ways to look at this. They either knew those drugs were destroyed, which is the interpretation I take, and they were hoping and praying that my guy took a plea so that this whole ball of wax wouldn't start melting. That's what I think happened.
Well, I just got a message from a viewer who makes a great point. That to remember, constables came into being to serve civil process.
Right.
Not to investigate crimes, not to do stuff like hold meth in the evidence lab.
Right.
So as this viewer says, it's not a big surprise that this happens out in Precinct 4 in a constable's office.
Right.
They're not set up for this. They really aren't.
Right. And in preparation for trial, I spoke with a constable from a different precinct who let me know how constables are hired, that they're not under civil service like HPD. They can get promoted based upon who they know, not what they know. There's not a lot of proficiency exams. So am I shocked that this happened? Not really. And the prosecutor himself told us that the reason he was offering such a low offer was because it was Precinct 4.
Of course. We've hit our 8:30 hour, half hour right now. Want to let everybody know we're opening up the phone line, 713-807-1794. We got our first caller on the line, so let's drop it in right here. Hello. Thanks for calling Reasonable Doubt.
I just have a question. My little understanding about the office there, y'all keep talking about how this was this.
Caller, hold on.
Hold on,
We can't hear
you.
We can't hear. Try again.
Can you go again?
Can y'all hear me now?
No.
Nope, can't hear now.
You can hear now?
It's like a Verizon commercial.
It is like that Verizon
commercial.
Can you hear this?
I think we got a studio issue here. In the meantime, stay on the line, caller.
Yeah, we'll try and get back to you.
How about now?
How about now?
We
Oh,
can hear
you.
Now we can hear you.
Okay. So y'all were talking about how this was this prosecutor's case called Bianca Roberson. Why did this other prosecutor, Justin Kiter, stick his head in the door and decide to take over the case. I mean, why are they allowed to do that? And does that step on Ms. Roberson's toes as far as her ability to work out? Because I believe it was Mr. Morgan who said that she had a personal issue based on her history with Precinct 4 and this lieutenant. Why is this other prosecutor sticking his head in her door and threatening to take over a case? I don't understand how that works.
You want to address that?
That is a good question, caller. We were on the verge of making this case basically go away. I pointed out all the issues that I thought that there were legal issues with the Terry sweep, with the search of the car. The officer essentially pulled the guy over and did what's called a protective sweep because he saw basically a Nerf gun in the car, like one of those little plastic guns that shoots those little plastic pellets. And then it turned into this full-blown sweep. So I was able to communicate the issues to Bianca, and then her chief came in because it's a 25 to life case, and I think that's really the reason he wanted to be. I think that's the reason he had to be involved, was because there was serious felony time. But I believe that the reason that he wouldn't let the case go is personal, which I'm going to refrain from commenting on further. But all I can say is, if you're going to bring personal issues into the courthouse, you need to check it at the door.
Emily, okay, so how are you going to attack this case? You said you were going to do some out-of-the-box things. What do you mean by that?
Well, our jury selection was going to focus primarily on presumption of innocence. Paul and I recently, after getting an aggravated sexual assault of a child case dismissed based on a speedy trial motion, went to trial on a burglary of a building that the state tried, I think, 3 or 4 times. But they couldn't find 12 citizens of Harris County that wanted to give 20 years to someone for stealing pots and pans. And so we decided that we were going to start hammering away on presumption of innocence and let the public know exactly that the prosecutors are swimming upstream when they present a case, and that they, the jury, represent the current going against the prosecution, and that their job is to examine every single piece of evidence with a critical eye and a skeptical eye. That's one thing that we've been working on, is presumption of innocence. We did some role reversing, what that means is that I took on the personality of the person that I was going to cross-examine and try to find out what their motivations might be to lie. I believed that the eyewitness they had was not credible. I believed that he was going to say or do whatever he had to just to get the police out of his life. And the only way I was able to craft what I thought was going to be a pretty good cross-examination was by reversing roles with him and figuring out what made him tick, what his motivations were, and why he would even come to court to help the police. I mean, if this guy's done time, he's no friend of law enforcement. And so there's got to be a reason other than a subpoena that's going to drag him to court to point the finger at someone else. Mm-hmm. And so just different things like that. We don't want to give away all of our secrets.
So you got to save them for the next time.
Right.
So what did you say? And maybe he did, maybe he didn't. But if I'm in the situation, I'm looking at 25 to life. I spend a year of my life fighting this case. I spend every dime I have to keep myself out of jail, and all to find out that there's no case and the drugs are gone and there's been police misconduct or whatever it is all over this. And so then I, and maybe your client did too, is say, okay, what's my relief?
Right.
What happens now? The case is dismissed and I just get a thank you or a sorry and see you around? What happens next?
Well, he never got a sorry. He did get a nollie though. He did get his case dismissed. He should probably get his bond money refunded. That should be a good start. Maybe a formal apology from Devin. That would also be pretty nice. And maybe an apology from Mr. Kiter himself, considering he was so adamant that this innocent man takes 6 years of his life and suffer in a prison cell.
So we have on the heels of this article, for the individual who is sitting in jail, almost lost his job,
He
almost
lost
lost
everything.
his house.
That guy lost everything.
Right.
He's suing the county now.
Yeah.
So I mean, have you all encountered that, or what? I mean,
Well, we don't really want to get into a lot of the confidential communications with the client just yet as to what his thought process is. I can tell him that he was very appreciative of our hard work. His family continues to thank Paul, and via Paul, myself profusely. And so they're just really just taking it in right now. He was very close to spending the rest of his life in a 4x6 cell, not being able to breathe fresh air. And so I think that he's just in a little bit of shock right now, right?
I think that's fair to say.
Right.
Yeah. I mean, this is going to lead to a whole full-blown investigation, I think, of Precinct 4. I mean, it has to.
I hope so.
Hasn't it already?
Well, I don't know that it's been, I mean, maybe.
Right.
Maybe it's been initiated. Who knows?
The thing I feel the worst about, other than the fact that the client and the client's family had to go through such anxiety and the emotional roller coaster a jury trial and charges come with, and the fact that we, put in easily, I would say hundreds of, a lot of hours preparing. I feel bad that an officer had to lose his job. I don't know which deputy was fired. They did not release his name on the news last night. But in this economy, and especially if the officer had a wife and had children and had bills to pay like we all do, I guess I'm a softie, but I feel bad that a deputy had to lose his job for following protocol that's stupid.
Yeah. Well, I mean, it's a great work by you guys. I mean, it really is. You guys have done a great job investigating it, pushing it, and not giving up. And that's sometimes that's 80% of the way you get things done and over at the criminal courthouse. But it wasn't your biggest dismissal of the week.
No, it wasn't.
You had your own personal dismissal today.
I did.
Ms. Detoto, following on the heels of this.
I know. I might as well just retire now.
Defendant
let's see
Detoto.
here. You went against all the conventional advice.
Right.
That says he who represents himself has a fool for a client.
Right. I got that joke a lot today in court.
Yeah, you went against that, and you decided to march into Houston Municipal Court on the same day that Michael Watts represented himself to an acquittal
I'm
in
seeing
federal
a trend
court.
here.
I see a trend. You had the great weed caper of 2016.
I know. It's uncanny.
And it had nothing to do with pot.
I know. Isn't that weird? It had to do with weeds in a ditch in front of my house. I don't own a weed whacker or a lawn mower or whatever.
Any kind of lawn maintenance device.
I don't do lawn maintenance. And so I came home from Wyoming one day and I had a large yellow ticket affixed to my fence that said violation of code, yada, yada, yada. And I looked it up and it was for letting weeds grow in my front ditch. So I was going to go to court and fight it for freedom of speech. But it gave me a fix-it-by date. It gave me a fix-it-by date.
Where's Mark Bennett when you need him?
So I cut my weeds before the date, the date where they were gonna, I guess, haul me to court or whatever. So I thought it was done. Well, then I get another citation in the mail, and not only that, someone had ripped weeds from my ditch and put it in my mailbox. And I thought, who walks around that angry over people's yards that they have to do that? And so I set the case for trial by jury, which is my right in municipal court. And I walked into court, and people were shocked to see me there because I don't really go there a lot. And when I said that I was representing myself, the judge laughed and all the other people laughed. And I ultimately got it dismissed.
Except for the prosecutor.
Oh, yeah.
Who, look, I don't know who it was, but if I'm a younger municipal court prosecutor.
Probably somebody from one of the big firms.
And if I saw Emily Detoto walking in and saying she's going to defend herself, I'm just going to cut the case. I'm going to say, no, I don't think they knew. I don't think maybe the prosecutor knew who you were walking in there.
He didn't.
And, you know what? He might as well be glad that he dumped that case because I would love to have seen how you would have tore that man to shreds.
I was ready.
Good work all around. I'm glad you were able to get the.
Well, the
weed.
shocking thing is the investigator showed up. Normally, the cases get dismissed because witnesses don't show. This inspector showed up ready to testify against me. Of course he did. And
he knew who Emily Detoto was.
Well, and
he
so
was going to see you go down.
I showed them my cell phone and the picture of the weeds in my mailbox, and I said, "Let's go." And I waited there, and then I got my dismissal that I'm going to frame along with this dismissal and some of my finest dismissals.
You guys have done some good work. Good work. I want to move to the next big story from this week locally, and that is and this is kind of it's kind of a weird deal because we have an HPD officer who's been relieved of duty following the release of a video in a DWI case, and it's a pending case. The case has not been dismissed. There's 2 cases actually been filed. HCCLA President Tyler Flood actually represents the defendant in this case, who was charged with DWI, and we're gonna show a couple of the videos here soon. But a woman was arrested for DWI. She's taken down to I'm guessing either
61 Reasoner.
Was it Reasoner?
Look like it.
To do the breath test. She can't do the breath test, or she tries to do the breath test but doesn't come back. They get a warrant to draw her blood. She's going through the warrant, arguing with the officer. Next thing you know, closed fist right to her jaw. I'd like to play the first video if we can get that rolling so you can see the first angle of it, and let's let it roll here.
That's the law, okay? We have a warrant for your blood.
No, you don't have a warrant for my blood.
Yes, we do.
That's not,
the warrant.
That's bullshit.
That's the warrant for your blood.
Okay, when was this signed?
Just like 5 minutes ago.
5 minutes ago, this is not...
Now, that's just one angle of it. Of course, you can hear the officer say, "She effing clocked me."
I don't know if he actually hit. I mean, is it?
Well, and then we're going to get to that. We're going to show the second angle here because even though we're not true journalists, in the spirit of journalism, we want to cover all sides of this. But you can hear him say, "She clocked me." The exchange happens. The technician runs out of the room to go get another officer, and which you'll see better on the other video. And the officer who eventually punches her, Greg Clark, he claims she clocks him. Well, let's roll the second video and be the judge for yourself.
Give me 1 second.
What?
Back off.
No, have a seat.
No, sir.
Have a seat.
No,
Everything we do is being recorded, okay?
That's fine.
Nothing we're doing is
Hang on, hold on, don't touch me.
against the law, okay?
No,
We have a
hang on.
warrant for your blood.
No,
We're
you don't
going to
have a
get your
warrant for my blood.
Yes, we do.
That is
That's
not,
the warrant.
that's bullshit.
That's the warrant for your blood. Have
Okay,
a seat.
when was this signed?
Just like 5 minutes ago.
5 minutes ago, this is not...
So there's the other angle. As you and I were talking before the show, Julio, you can clearly see her arm go back. Now, they filed assault public servant charges
Of course.
on her, indicted her, felony indictment pending. And what they claim in the indictment is she struck him with her elbow. Okay? I mean, you can kind of see that from the video. I'll grant them that you see her arm go like this. But
Is it a reaction?
Right.
Is it her intention?
Right.
What are some of the things? I mean,
and you guys are just seeing the video for the first time, I think,
Right.
because obviously you've been involved with other stuff.
Right.
And getting 25 to life cases dismissed. What's your impressions of the video as we just showed it to you?
First, I want to know, how did the public get this video?
It was was released. I'm not real sure.
Okay.
Well, I'll elaborate.
I mean, the
Do
news
we
got
think
it.
the prosecution gave it to him? I say no. I say, and I don't even know if they've even watched the video yet, and they
Again,
won't
I
watch it until trial.
Again, Paul, I said we're quasi-journalism. I
Right.
didn't say I would get the full story. I just said I had some of the story.
The way I look at it, it looked like she was, her hand was raised because she didn't believe that the warrant was valid and she was reading it. Playing devil's advocate, I don't think that when the police are asking you to do something that you should be waving your hands around and saying no and talking back to the police. I just don't think that's ever a good policy.
Not a good strategy.
You could
But
die.
yeah, exactly. But from my angle, and I'm not a true believer. I don't think everybody's innocent. I'm a criminal defense attorney, but I also am a common sense human being. I don't think she struck the first blow, and I think what he did is absolutely disgusting.
Yeah, why can you not question the police to challenge you a little bit? If he comes in claiming that he has a warrant to draw her blood, why can't she ask questions about the warrant? Why was she incapable of actually calling BS when she actually thought it was BS? She had the right to sit there and look at it before a needle went into her vein for a misdemeanor.
Right. She does have that right, and she's lucky she didn't end up dead, to be quite honest.
Yeah.
True, but is it fair to then charge her with the third-degree felony of assault public servant?
Right. Well, we're way past that. It's not should I, it's I will. I mean, it's just because I can, I will.
It wasn't even a question.
Right.
I mean, the biggest issue I have is, when is it ever appropriate for an officer, a male officer, to close fist punch a female suspect, regardless of the situation?
Right.
She
Well,
wasn't armed.
No.
She wasn't dangerous.
Exactly.
She was in a controlled environment. There was another officer there. It doesn't even look like she could have hurt that officer even if she wanted to.
No. I don't think so. We've got another call coming in. Let's jump on the phone lines here. Hello, thank you for calling Reasonable Doubt.
Hey, I wanted to ask a question about the dopeless dope case real quick. So I'm hearing that the DA's office knew since April, and I'm just curious if the DA's office had actual knowledge, or are y'all talking in the sense that because the agency knew, the DA's office knew because of Brady and, they're the agency and it's, that legal type knowledge. And if they did have actual knowledge, how do y'all know that?
Great question. Thanks for calling in. My understanding, Paul, what you told us was the actual spokesman for the office said that the office knew since April.
Jeff McShann told ABC that they knew that these drugs were missing since April, and that there was an investigation in Precinct 4 regarding the disappearance of these drugs. Now, legally speaking, caller, whatever knowledge the law enforcement has is imputed upon the prosecutors. So if a prosecutor is prosecuting a case and an officer has an offense report or has some sort of dash cam or whatever he knows, that's imputed upon the police. I think you could get to a misconduct argument, or you can claim misconduct through that type of argument. But here, what it sounds like is that Jeff McShann told ABC that they had actual knowledge that these drugs were missing. So I don't know if he knew that these drugs were missing in this specific case, but he told ABC that he knew that missing drugs were being investigated in Precinct 4.
right. The first time we found out that the date that the drugs were destroyed was when we saw it on the news. At least that's when I found out. I knew that they were destroyed, but we couldn't get an answer as to when or by whom. And Jeff McShann, I mean, he's no slouch. He used to be a journalist. The reason he has that position is because he's, a good spokesperson for the office. And if he says that the office knew since April of 2016, you know he's going to double, triple, quadruple check before he says something like that. And so at least he's admitting that he knew. Whether the trial court prosecutors knew is doubtful. That's my position. I'm sure Paul disagrees.
I take a much different position. I personally believe that they were pushing the case to a sentence to try to cover this up.
Well, it's a great call. Appreciate the question. I guess we'll see more as it unfolds. I want to go back to this DWI case though, because you know, as I said in the outset, this officer has now, according to Channel 13, the officer has been relieved of duty pending an investigation of everything, or he's off the streets, is what they say. I mean, from a defense lawyer's perspective, guys, he's now off the streets. Obviously, there's an investigation into his conduct, but they haven't dismissed the cases. Cases are still pending. How does that play into cross-examination?
Well, I mean, the DWI has now become irrelevant. It's what you call leverage. If you get pulled over on a traffic violation and you're not wearing your glasses when you should, and you also don't have your license or your insurance with you, can they write 3 tickets? Yes. Will they? Yes. Why? Leverage. And so the DWI case has become irrelevant. I think that now the bigger picture is let's charge her with a felony. And they can't really dismiss it at this point because it's on video. Her actions are on video. The officer's actions are on video. And I think if they were to dismiss the case, it would be a quasi-admission that the officer was out of line. And we've seen firsthand how it takes pushing and pushing and pushing to finally get justice.
Is she indicted?
She is. She's indicted.
And you know, I wonder if the grand jury had an opportunity to see this video before the prosecution went in there and just said, so and so did on such and such date assault a public servant, to wit, you know, via her fist or hand or arm. I wonder what a grand jury would say. And I'm wondering if I'd assume that grand jury is still impaneled and still around, and they're seeing this stuff unfold in front of them before their eyes, and knowing that it was their stamp that allowed this individual to be indicted on this charge. And I wonder if they feel kind of cheated or taken. We have viewers that are on grand juries that have called before. And so I'm wondering, I guess they can't talk about it, I suppose, but
not really.
I know if I was a grand juror and I stamped my approval on it, and this video came out, I would feel like I've been duped, like I was cheated. And I would have a huge ball in my stomach of remorse, of guilt.
I mean, Emily, if you're a prosecutor, put back on your prosecutor hat for a second.
Okay.
Would you have presented that video to a grand jury if your goal was to try and get an indictment?
Absolutely not. That video, I mean, you nailed it on the head. No matter who provoked what, for a man to close fist punch a woman, that does not help your case for a grand jury to see.
No.
And so my question is, I mean, when the defense got the video, they certainly they don't have a right to present evidence before the grand jury, but they certainly could have presented a grand jury packet and maybe requested that the grand jurors view the video. But I think the way this is looking already, the cart came before the horse. Maybe the video wasn't available at the time the case was indicted. Maybe they pushed it through knowing that there was this video, and that Tyler, being a good lawyer, would probably present a packet and suggest that the jury watch the video, the grand jury watch the video.
Yeah, I mean, it looks like I've got the docket sheet pulled up here. It looks like the complaint, it comes out March 30th. 30 days later, April 20th, is the indictment comes down.
Right.
I mean, 30 days isn't enough time to put together a packet.
No.
But it is enough time, because we know that the 61 reasoner blood draws pop onto the district clerk's website very quickly. Now, the scene videos might not be, the dash cams might not be, but those blood draw videos are up. And I would be very surprised if that video wasn't available, at least to the government.
Well, but here's the
Before
thing.
that
So I've gone
indictment.
through here. It appears to me her first court setting was March 31st. It's reset until May 12th, and it has to hire an attorney. So she was indicted before she even got a lawyer.
Yeah.
So
Felony?
that's what it appears.
Right. She didn't have the chance.
How much was the bond?
Good question. $5,000.
Yeah. Officer punches you in the face and you have to make a $5,000
No
bond.
bond.
Well, and I'm wondering if this type of scenario might be solved or at least helped with an attorney at the PC court, at the PC hearing right away. You know, I wonder if she could have said, or at least with the bond, an attorney could have spoken with her and said, hey, let's talk about the nature of the crime and the severity of the crime. You know, she was close fist clocked in the face by an officer twice her size, you know, and talk, you know, maybe if a PC judge had heard something like that, maybe she wouldn't have had to post a $5,000 bond or something.
Maybe so. Maybe so.
That's a good
we
point.
only got a minute left, Julio. Probably a little less.
It's too fast.
Wow, that
Too
went
fast.
fast.
We will
This is,
have
like,
part
quick.
2 of Emily Detoto and Paul Morgan next week.
We're gonna get them back on the show. No, I mean these are two very interesting cases because I think they're going to lead to some. Obviously, officers admitted there's an investigation going on in Precinct 4, and now I think there's going to be an investigation on this officer. I mean, he's been relieved of duty, so these are two pretty big issues to watch out for here, and they're being covered. Both of these cases have been covered by Channel 13, so I'm sure that those journalists over there are real journalists. They will do a good job getting all the facts and presenting them to everyone. But in the few seconds we have left, I want to thank both of you guys for coming on.
Thank you.
Really appreciate you guys taking time out of your Thursday night to come down here.
Well, thank you.
Absolutely.
It was fun.
Glad you could make it. Finally,
Now I
make it down.
regret saying no all these years.
Spurning me.
She did the same thing to
It
me,
makes you
man.
want me
I've been
more.
trying to
Right,
get her out of it.
exactly. She knows how to do it. Anyway, ladies and gentlemen, that's all we have for tonight. For my co-host, Julio Vela, and our guest, Emily Detoto and Paul Morgan, we thank you for joining us, and we'll see you next week. Good night.